Seated at council table with Attorney Griffin is Sarah George.
Thanks very much. Counsel?
Good morning, Your Honors.
Good morning.
It is not a crime to peacefully distribute a flyer asking someone to join a group, nor could it be under the First Amendment. But before this court considers the constitutionality of the statute itself, it should decide once and for all that the term behavior in the disorderly conduct statute, specifically violent, tumultuous, or threatening behavior, captures only physical violence, physical conduct, not speech. Such statutory construction would be consistent with this court's prior
Can I go back to your first sentence so I understand your view? It appears that the trial judge responded to that this is actually a recruiting page rather than an overtly threatening page, on the basis that if it's sent only to minorities, and by whatever evidence the state has, only two minorities got it, that those people, reasonable people, would in fact interpret it as a threat, despite the fact that it might look like superficially an invitation.
The court there went and considered the expressive activity and the content of the flyers, but I think before you even get there, the question, is it a crime to pamphlet the homes of people who happen to live there for Mexican-American and African-American? It is not a crime to pamphlet. It is not a crime to ask someone to join a group.
But one of the things that struck me about the appellate's brief is that the whole constitutional analysis has to rest on a shared understanding of what's the factual scenario we're evaluating. And there was a motion to dismiss, and the court had a hearing, and so we've got both findings and we've got the state's best evidence, which I assume is how we should view this on motion to dismiss. So you keep asking us to look at this as a recruiter who happens to hit a home in which an African-American person lives or a Mexican person lives, as if that's the scenario, when I think the record that we're stuck with is a record that says that these flyers were targeted specifically to those people for the purpose of intimidating them. Isn't that something that you could infer from these facts, and therefore shouldn't we evaluate it that way?
No, you can't infer that from the facts. I think what you're asking, too, is implicitly is how to treat the facts found by the court along with a constitutional question here, which is, of course, where the facts are significant for constitutional purposes, whether or not they're in fact threatening, whether there was purposeful intent to intimidate, actual violence on the recipients. That is reviewed de novo. In terms of...
And is it reviewed de novo as in we're weighing the evidence, or is it reviewed de novo since it's a motion to dismiss? There's no deference at all. We're treating it as if we're looking at the same evidence on the motion to dismiss.
Yes, I think in that instance, though, it has to be careful that we're not giving any deference to any implicit legal conclusions, like the inference of targeting, for instance. I think the undisputed evidence was that only 2 people were confirmed to find this flyer. But what's also undisputed is that the actual express message on the flyer was an invitation to join a group. There's no message of violence, generally, or violence specific to the people who received it. There is actually evidence listed in the state's case where the detective confirmed, telling Mr. Schenk that he didn't think that the message itself was threatening. But before that, I think that presupposes the initial threshold question that this court must address before getting to the constitutionality question, which is, what does behavior mean in our disorderly conduct statute? And under the doctrine of constitutional avoidance, this court must resolve this if in a way that's readily apparent, and our briefing establishes how that is. And if so, if interpreting behavior to just capture physical conduct, that avoids the constitutional question entirely, and you don't even get there.
How does it avoid, I mean, I'm trying to figure out how that construction of the statute makes it more or less problematic constitutionally, because I assume that means that a person who stands in the middle of the street, looks right at you and says, I'm going to put a gun to your head and shoot you if you take another step, is not subject to prosecution under this statute. But somebody who flails around and perhaps has something less overtly less overtly threatening might be subject to prosecution, depending on how the gestures are interpreted?
I think the argument is, what is the physical gesture involved? We have lots of statutes where we require a physical component to threatening behavior. Aggravated assault, use of an armed weapon, stalking, course of conduct. Threatening behavior, disorderly conduct is no different. I think that not only has this court's decision, State v. Alvarelli and State v. Tracy, acknowledged the difference between behavior being linked to physical conduct as opposed to speech, the legislature has itself clarified. It chose the words behavior, not words, which it chose to use in the criminal threatening statute under 1702. The model penal code that is equivalent, the most closely equivalent to disorderly conduct, punishes mere threats, not threatening behavior. Again, I think that this court need not go any further than looking at the plain text of the statute. Threatening behavior.
Can I go back a little bit? The trial court went through the 5 Alvarelli factors, so it went through exactly this question of behavior versus, and I'm not sure whether in response to Justice Robinson's question, you agreed that one of the components was there, which was that this was an example of targeting. These people were targeted. It's so that it was directed at a particular person, one of the Alvarelli factors. Again, in the fact-finding, you've got the prosecution said, we tried to find anybody else. There wasn't anybody else. These 2 people are the only ones that we know of. I know your client said, no, I gave it to 30 or 40 different people, but this is prima facie case. Is targeting proven here sufficiently?
Again, I would stand that it's not sufficiently proven. We don't need to discount the defendant's statements here. They were brought in by the detective itself. It was unmodified, uncontested. So that certainly isn't required. But regardless, even if this court could find there was sufficient evidence of targeting, that conduct of targeting an audience to hear a particular message is not a crime, and it's not a
Isn't that what
threat.
happens at abortion clinics? Aren't those people targeted for the
That's right.
speech?
That's right. And again, what we're doing, though, is inherently, when we find that targeting is significant, we're necessarily assuming that we are looking at the speech activity itself. Again, presupposing that the disorderly conduct statute punishes and captures speech.
Well, the disorderly conduct, as interpreted in Alvarelli, requires a significant physical component. It doesn't say, and you can't use speech. If you have the significant physical component, you can use speech, right?
I would say that any time that speech is considered and is the determinative factor, that we can only know that the physical component is threatening because of the content or message expressed. Now we're in First Amendment territory. And
Before we get to First Amendment territory, in the printed case, is this the flyer? Because I went to the court records below, and I couldn't find a flyer in the file. I'm assuming a flyer was introduced during the motion to dismiss?
yes, Your Honor.
Is this it?
That's the flyer.
Okay.
And the flyer, again, the act of leafleting isn't a threat.
Now, the trial court seemed to be particularly focused on the fact that the flyer contained the burning cross, or the representation, obviously, of a burning cross, and went back to the U.S. Supreme Court cases on burning crosses and the association with the Klu Klux Klan, and that the burning cross is a symbol that indicates violence may be forthcoming. What's wrong with that in view of the Supreme Court cases?
Virginia v. Black reviewed an actual burning of a cross and determined that that in and of itself is not evidence of a true threat, as that is narrowly defined under the First Amendment. Here we have not only that same image, but actually associated, long associated with a symbol of the particular group being advocated on behalf of. We also have a message attached to that symbol of this group. The message is not at all indicating that violence is imminent or at all threatened to these individuals. Join this group. right? Couldn't be more express of an invitation to join a political group. In fact, this kind of activity is not just not a true threat, not a true threat remotely under the First Amendment. It is core protected political speech. But again, this court need not address this if behavior is limited. It's interpreted as being limited to physical
So what is
violence.
physical? If we said that the statute is limited to cases in which there's an element of physical behavior, I take it you don't, the act of placing a flyer in somebody's, between their doors is not physical conduct. What, does it have to be face-to-face?
And I assume again, is there a verbal threat involved, or is it a physical threat? I think that's where context matters significantly. If it was just handing out the pamphlet, then certainly there would be a 12D motion filed, because what is the action there that is inherently threatening?
Now, the trial judge said about that, here there was no direct face-to-face confrontation between the defendant and the complaining witness. However, there was a significant physical component to defendant's actions when he, without license or privilege, entered a portion of the victim's home, that is her screen door, and the other victim's home, her mailbox. As noted above, a person has a heightened expectation of privacy in the home or its curtilage. So what's wrong with that analysis of a physical component?
Your Honor, I would refer you to the amicus briefing on this issue, which really identified the long line of cases by the U.S. Supreme Court addressing the issue and upholding this as squarely protected activity under the First Amendment. Leafleting at the home, and literally, unless there is a do not trespass notice, do not leaflet, readily visible, it remains protected.
So let me
activity.
shift it a little bit, because the use of the term leafleting conjures an image that is arguably at odds with the facts as we're supposed to take them. Let's assume that the paper was more explicit, and it didn't say join our group, it said do harm to non-white people. And it urged people to do that, do physical harm to non-white people. It's leafleting, but let's make it death threats. Let's say kill non-white people. That's leafleting in the sense that it's putting a piece of paper in someone's door, but are you arguing that the core constitutional protection that you're describing would extend to that?
Yes, I would, Your Honor, even with that content. National NAACP v. Claiborne Hardware Company, the U.S. Supreme Court said even the advocacy of violence is protected activity under the First Amendment. I'd like to reserve the remainder of my time.
Okay, thanks. Counsel?
Good morning, Your Honors.
Good morning.
Opposing counsel, may it please the court. This is not a case about suppressing defendants' free speech rights. This is a case about the defendant's entire conduct, taken in context of all surrounding circumstances, that he specifically targeted two individuals, two women of color, at their homes and placed a Klu Klux Klan flyer on their door.
Now, there's no evidence that he knew the occupants of these premises were minorities, is there?
There is no evidence that he knew that they were minorities. However, we are taking at this stage the evidence in a light most favorable to the state. We are at a motion to dismiss stage. Also, we do understand throughout case law and with this court that intent is rarely proved by direct evidence, and that it has to be inferred from a person's acts and proved by circumstantial evidence. And the evidence that the state put forth were from witnesses who, first of all, received the letter, spoke to their neighbors, asked around, looked for the letter as well, and found no other letters. Also, we had Detective Nash, who spoke about how Burlington police went around canvassed neighborhoods 2 to 3 blocks around the diameter of the home on multiple occasions. They also put out press releases to many different news stations asking for people to report that they had received this flyer.
Now, I do understand that this is a prima facie case and all of that. It goes to whether they could gather any evidence of other people. But it would it strikes me as it would be sort of inexplicable that in a city that has now a growing minority population, these two were selected for some reason, but we have no idea what the reason was.
Well, at this stage, Your Honor, a reasonable jury could infer that they were targeted. I would direct your attention to the fact that they weren't even next-door neighbors. In the transcript of the motion to dismiss, Ms. Hughes actually states that Ms. Harvey, the other complaining witness in this case, technically lived on her street, and that she had asked her next-door neighbors whether or not they had received the letter. So we have evidence to show that these are the only two women in the entire neighborhood that received the letter and taking the light most favorable to the state. That's the evidence we have, that these are the only two, and it could be inferred that it was the defendant's intent to target these two women at their home.
And if that's the case, are you suggesting that the speech loses its constitutional protection if they were targeted?
Yes, I would, Your Honor.
Just on the fact that they're targeted?
I would say the entire conduct, which includes the targeting. I would say the entire conduct of the defendant targeting these two women who are both minorities. We understand that one is identified as Mexican while the other identifies as an African American. We know that he placed the flyer on their door. We also know that if we look at the flyer itself, which this court has said you are able to do, you are able to look at conduct which includes speech in order to determine whether or not it's threatening behavior or a true threat, which is an exception to the First Amendment protections. And when we look to the flyer itself, we see the depiction of the hooded Klansman holding up a burning cross. We see the words, "Join the Klan and save our land." Not just join the Klan, but also to save our land. And when we look at the history of the Ku Klux Klan, we know, as a society, that the Ku Klux Klan's methods of saving our land include egregious and violent acts towards minorities. This shows that a reasonable person in the state of these two individuals would be fearful, would feel threatened for
Would
impending
any
harm.
communication, would any content on that flyer, insofar as it was distributed from the Klan and we're inferring they targeted these two women because of their ethnic background or their race, would any communication from the Klan be a true threat and therefore not constitutionally protected because it's the Klan?
I would say that yes, if the evidence shows that he is specifically targeting two minorities, providing a flyer on the Ku Klux Klan, a reasonable person can, in fact, be threatened.
So it has nothing to do with whether it's a person with a hood or a robe. It has nothing to do with whether they're on a horse. It has nothing to do with their holding a burning cross. As long as it says the words Ku Klux Klan, that would be enough for you to have a case.
I would say that it would be enough. I say, though, in this case, given all of the context that you have just spoken about, that's what makes this case even stronger.
Has any case
Wait a minute.
gone as far as you're suggesting here? Can you give us a case that would say that's enough?
I cannot give a case that would say that a flyer in and of itself is enough. However, this flyer in the context is much different than just inconspicuously leafleting flyers. This is targeting.
But you're saying any flyer that has no horsey and no burning cross and nothing, it just says, join the Ku Klux Klan and make America great again. I don't care.
Or something like that.
Okay, something like that. That alone, putting that on a door, in a screen door, targeting the whole city would be a violation of the disorderly conduct statute?
Now, if we're talking
No,
about
no.
targeting.
So you're saying if it only violates the statute because it's threatening behavior against these two women?
Yes, Your Honor. If we are targeting minorities, if we are targeting the people that are clearly not associated with the Klan, clearly know the history of violence against their race, against their ethnic origin, that in and of itself is a threatening behavior. It is not, as Your Honor mentioned, targeting the entire city. If we were talking about indiscriminately going through the entire neighborhood, leafleting that flyer in the neighborhood, no matter who lived in the home, no matter what race, no matter what gender, this would not be threatening behavior. But we are talking about specifically targeting 2 women of color.
What about leafleting women that are going to get abortion services?
Your Honor, I would say that in that case, it would depend on what it said. However, the
Save a life, raise your child.
I think that there's a big difference between groups that oppose abortion clinics versus the Klu Klux Klan. And the reason why is because I have a hard time thinking of any group who has the same history, decades of violence.
How about the Westfield Baptist Church group?
Your Honor, I would go to Snyder v. Phelps on that case.
Yeah, right.
And we do see that obviously the Westboro Baptist Church has been around for a long time and has been considered to be an annoyance, distasteful.
Can you distinguish it? The Supreme Court said hurtful and hateful speech causing undisputed extreme emotional distress and suffering are insufficient reasons to suppress speech.
Your Honor, I would say that that is different from here because emotional distress is much different than a true threat. That actually requires reasonably feeling an expression of an intent to actually do harm.
And that's an objective standard.
Yes, it is, Your Honor. It's an objective standard. I would also point out in Snyder v. Phelps that the Supreme Court not only spoke to the distasteful content, but they also talked about how the message was conveyed, the fact that it was in an area close to the church, but in a blocked-off area, that they were not unruly, and how it was conveyed. The fact that they were there picketing, which is, there's no question that there is a First Amendment protection to picketing in certain situations, and
So if he'd stood outside these 2 women's homes holding up this poster, encouraging them to join the Klu Klux Klan, it would not be charged with disorderly conduct under our statute?
I would say that that is also different from Snyder v. Phelps, in that that would be specifically going to their homes where they have this sense of security and privacy in their home, whereas this was at a public area by the church where they were not in any way forcefully directing their actions towards a specific individual.
What if he stood on the sidewalk in front of their house specifically because they were black?
Your Honor, I would say that specifically targeting them with the flyers that depicted the burning cross and was clearly affiliated with the Ku Klux Klan, if he is specifically targeting minorities, that would still be threatening behavior.
So the trial court indicated that it had to get over the 5 Alvarelli standards just to find there was a disorderly conduct violation, apart from the true threat. And one of them was that the conduct included a significant physical component. And it found that component by going up on the porch and either putting it in the mailbox or putting it in the screen. Now, you seem to be arguing that no physical component is necessary, that if he just stood outside and waited till they came out or were going in and handed him a leaflet or showed him a leaflet, that would be enough because targeting covers everything. How do you square that with the trial court decision?
I would say that, in fact, my understanding of Alvarelli is obviously there needs to either be a directed threat at a particular person or some significant physical component. And Alvarelli, this court spoke about how there was no direct threat to any particular individual.
So it's threatening behavior. Isn't Alvarelli about behavior and that it isn't about, and then, of course, it leads to, in order to narrow, and the trial court said that it was adopting the narrowing construction of Alvarelli. Isn't it trying to get away from speech and into conduct? And you seem to be going back to speech.
Well, I would say, Your Honor, also that there would be a significant physical component. If he is targeting these homes, he is going to the homes, and then he is waiting for the individuals to come out to give them the flyer.
Where is
I believe
this
that's
coming
also a
from?
physical component.
Where is that coming from?
That is just my interpretation of the significant physical component, in that
There's no evidence of that.
there's no evidence that he, in fact, stood on the sidewalk and
Or
waited.
waited
No.
outside their homes for them to look
No, I'm
at-
just speaking
yeah.
of the hypothetical that's being spoken about, where you're Justice asked for whether or not they were standing on the sidewalk, holding up the sign. I would say that if he is, in fact, targeting those homes of minority women, then there is a significant physical component of going to those homes and targeting those homes.
The amicus, I think, argument in particular is that we should find the necessity of intent to intimidate or threaten or whatever. Do you agree that if intent is required, that you don't have it?
I do not agree that if intent is required that we don't have it. Again, we are looking at the evidence in a light most favorable to the state at this stage. And when we look at the fact that obviously we will never get every case to have intent shown through direct evidence. We look at the facts in the context of the situation, and looking at all the facts that the state has put forth in a light most favorable to the state, a reasonable jury could infer that the defendant intended to communicate a
So
serious expression.
even in what seems to me to be from the interview, even if you can't get anything from him that indicates at all that was his intent, and he denies it.
Even if he denied it, we're at a motion to dismiss stage, and that would be modifying evidence at that time. Right now, we are looking at the evidence in the light most favorable to the state.
But you didn't charge him with intentionally doing it. The disorderly conduct charge is recklessly caused it.
It is reckless, and reckless is a level of intent. Now, if we are speaking about specific intent, I do understand that there are different levels of intent. But if this court should decide that specific intent is required, I do think that we have enough at the motion to dismiss stage in a light most favorable to the state, that there was specific intent to communicate this expression of intent to do harm. I would point out that State v. Albarelli did explain that it does not need to be an explicit threat, nor does the defendant need to intend to actually do any harm. It's the intent to incite fear in someone. And Your Honors, I would also speak to the elements of the disorderly conduct statute and how the state at the motion to dismiss has in fact met these elements.
How much time is left?
1 minute remaining.
Could you address the claim that the enhancement for the hate crimes doesn't offer any new element to the charge of
Yes, Your Honor. In the hate crime sentence enhancement, that was constitutionally applied by the state, and I think that you're speaking regarding amicus ACLU's argument that there should be some extra harm in order for this to be constitutionally applied. However, that has, I did not see any case law that would show that in fact there needs to be some extra harm. All that is required of the hate crime sentence enhancement is that a crime has been committed and that it was maliciously motivated by a victim's perceived or actual race. And we have shown that here. And if we look at Wisconsin v. Mitchell, they explain that that extra societal harm, the purpose of a bias-motivated crime, is that bias-motivated crimes are more likely to provoke retaliatory crimes and incite community unrest. And because of that reason, that is the purpose. Thank you, Your Honors, and I would say that based on this argument and all arguments in written brief, we do ask that you affirm the decision.
Thank you very much.
Appellant has 2 minutes and 15 seconds remaining.
Thank you, Your Honors. First, targeted speech is protected speech under the First Amendment. Snyder v. Phelps is the easiest, most recent case on that.
But threats aren't protected, right? So the question here really is, does this qualify as a true threat?
That is the question if this court interprets the disorderly conduct statute as in capturing speech, and whenever any speech is looked at to determine whether the physical component is in fact threatening, that is there. The true threat speech, as we've argued, and as Virginia v. Black makes clear, specific intent on the part of the speaker is required. Now, the prosecutor said it's an intent to harass or an intent to incite fear, and it's actually much more specific than that. It's an intent to cause physical violence, but that's not even narrow enough. It's an intent to cause physical violence on the recipient. And here you can see the case.
Now, you understand that while that is a possible interpretation of the Black case, that it seems like that the majority of federal circuits have not gone that far, and particularly, of course, the prosecution is emphasizing the Second Circuit on that point.
Yes, Your Honor, I would point this court to a decision, a concurring opinion by Justice Sotomayor issued 2 days ago, and I'll follow up with the site Perez v. Florida. It was a denial of a petition for cert, otherwise unworthy. However, she submits 4 pages where she says in a concurrence that specific intent as a requirement for true threat unprotected speech category was made explicit as a requirement in Virginia v. Black. But even then, having specific intent and a reasonableness requirement isn't enough. As those decisions have made clear, context of the speech itself at issue is necessary. Why isn't a reasonableness standard enough? I think inherently it turns on a majority rule analysis, leaving all minority opinion, dissidents, inadequately protected. It leaves wide discretion to the police and the prosecutors to decide what is offensive. I see my time is up. Thank you.
Thanks very much.
The next hearing for the court is scheduled for 1:30 this afternoon.
All rise. Coming out here.